Now, I'm very happy to announce our next keynote speaker. He's already waiting. Thank you very much for waiting a few minutes. It's once again Thomas Zerdick. He's head of unit at the European Data Protection Supervisor. And he will once again this year, as already last year, share his outlook on the current and future challenges. Mr. Zerdick, thank you for your time, and the floor is yours.
Good afternoon, ladies and gentlemen, and greetings from Brussels to my hometown, Berlin, and thank you very much for the kind invitation again. It's an honor to speak at the Bitkom Privacy Conference 2025 under the title The Road Ahead for the EDPS, Addressing Current and Future Challenges in Personal Data Protection. Now, as you know, since 2004, the European Data Protection Supervisor has been the independent authority tasked with ensuring that union institutions, bodies, offices, and agencies comply with their data protection obligations. Today, we supervise 75 EU institutions and agencies across the 27 member states. This covers the European Commission, the European Parliament, Europol, the European Medicines Agency, the European Investment Bank, and many, many more. Our mandate is broad but clear. We monitor and advise, we investigate and enforce, and we cooperate with other supervisory authorities, in particular through the European Data Protection Board. We also provide the secretariat to the EDPB, helping to ensure a coherent application of data protection laws across Europe. The EDPS has the same toolbox as national DPAs, but with the particular responsibility of ensuring that the EU institutions themselves set a high standard. After all, if the EU institutions cannot demonstrate compliance with their own law, their credibility in legislating and enforcing that law elsewhere is undermined. Now, update, in case you missed it, EU member states and the European Parliament have been in something of a deadlock since the start of the year over the appointment of the next European Data Protection Supervisor. Until that decision is taken, it is of course difficult to define the longer-term strategy for the next 5 years for the EDPS. But let me reassure you, with Wojciech Wiwerowski continuing to serve as acting EDPS, the ship is certainly not without a captain. And indeed, the EDPS remains very active, supervising, advising, and enforcing, just as you would expect. In the next minutes, I would like to take you through 3 central themes for us in the EDPS here in Brussels. First, supervision and enforcement in practice. And I'll be using the Commission's use of Microsoft 365 as a concrete example. Second, legal clarity through jurisprudence. And I'll be drawing on the recent judgment of the Court of Justice in the SRB case. Third, forward-looking priorities, focusing on accountability, new technologies, and international cooperation. As you've heard at last year's Bitkom Privacy Conference, I presented to you the EDPS decision on the European Commission's use of Microsoft 365. In that decision, we found serious infringements of Regulation 2018/1725, or EU DPR, in relation to purpose limitation, international transfers, and unauthorized disclosures of personal data. We ordered the Commission to take corrective measures, including suspending transfers to Microsoft and its sub-processors located in non-adequate third countries. The Commission had until December 2024 to demonstrate compliance. After receiving the Commission's compliance report and after holding intensive discussions with its services, we concluded that the factual situation had significantly changed. Additional contractual, technical, and organizational measures had been implemented by the Commission in cooperation with Microsoft and with our oversight. Transfers were restricted, recipients and purposes clarified, and safeguards against unlawful disclosure requests strengthened. For me, 3 lessons stand out from this case. First, enforcement works. Sustained supervisory pressure, coupled with legal obligations, leads to real improvements in practice. This investigation was not about issuing a fine, but about correcting infringements and restoring compliance. Second, cooperation matters. A constructive relationship between controller, processor, and supervisory authority is essential. Without it, enforcement risks becoming symbolic. With it, enforcement becomes transformative. Third, and I would argue most importantly, this case sets a benchmark. Other EU institutions, and indeed other national public authorities, know now what level of safeguards can be required and applied when using cloud services, especially when using Microsoft 365. We have published our closure letter of 11th of July in full on our website. Now, was the EDPS too lenient? Some commentators have suggested so. My clear answer is no. Our intervention led to credible and measurable improvements. The EU Commission is now demonstrably in control of how Microsoft 365 is used within its environment. In addition, the Commission has made the recent improvements to the interinstitutional licensing agreement with Microsoft available to other EU institutions that are contracting Microsoft 365 under this specific contract. This is a success for accountability, for transparency, and ultimately for data protection. Again, for me, the broader implications are clear. Cloud services remain indispensable for modern administration, but they must be used on European terms with safeguards that reflect European law. Let me quote European Commission President Ursula von der Leyen's State of the Union address. We set our own standards, we set our own regulations. Europe will always decide for itself. It also means that supervisory authorities must not shy away from complex multi-year enforcement cases. Persistency pays off. International transfers, contextual clauses, and technical measures are, as we have seen, not abstract concepts. They determine whether rights are respected in practice. Again, this case also shows that enforcement is not an end in itself. Closing a case, as the EDPS has now done, is not the end of supervision. It's a milestone. We will, of course, continue to monitor EU institutions, and we expect other EU institutions using Microsoft 365 under this interinstitutional contract to carry out similar assessments like the Commission has done. The EDPS's closure of these enforcement proceedings also does not mean that the EDPS has certified or endorsed how any other entity uses Microsoft 365 services complies with other EU laws, such as the GDPR. Therefore, what we do is we, as EDPS, we are already informing our colleagues and other supervisory authorities and in other EU institutions about this decision to close the enforcement proceedings against the Commission. And the EDPS will share the lessons learned as widely as possible. At the same time, and I'm looking at the colleagues who are online from other supervisory authorities, without your active involvement, that means without the active involvement of national data protection authorities, it will be difficult to ensure that these improvements are embedded and extended across the entire European Economic Area. The second theme I want to highlight today is the importance of jurisprudence, or European case law. As lawyers, we know that the law is clarified and developed through cases. That, of course, is particularly true for European Union law. For supervisory authorities, judgments are not only guidance, but also tools for future enforcement. As you know, on 4th of September, the European Court of Justice issued its ruling in the SRB versus EDPS case. The facts are technical, but the implications are profound, since it is about the concept of personal data. As you know, as a European body, the Single Resolution Board, the SRB, is not subject to the GDPR, but to the regulation 2018-1725, the EU DPR. Again, however, as you know, the provisions of the EU DPR and the GDPR on the meaning of personal data and on many other points are identical, and where this is the case, they are to be interpreted in the same way. So, for the facts, in essence, the Single Resolution Board, in the context of resolving a Spanish bank, shared comments from shareholders and creditors with Deloitte. These comments were pseudonymized with codes instead of names. We in the EDPS considered this personal data and found that the SRB as controller should have disclosed the sharing with Deloitte as processor in its privacy notice. Very simple, every day-to-day thing, and essentially one line in the privacy notice. Now, the SRB took us to court, and the General Court agreed with SRB, disagreed with us, holding that since Deloitte could not identify the individuals, the data was not personal from its perspective. The EDPS appealed, supported by the European Data Protection Board, and the Commission intervened in support of the SRB. Now, the Court of Justice has clarified several key points. 1. Personal views or opinions necessarily relate to the natural person who expresses them. This seems obvious, but it needed to be confirmed. 2. Identifiability must be assessed contextually. The court has embraced, in our view, a practical case-by-case approach, rejecting both absolute anonymity and absolute identifiability. 3. Pseudonymized data are not automatically personal data, but nor are they automatically anonymous. Each situation must be examined in its own context. And 4, the controller's perspective matters. The SRB, as controller, had an obligation to inform data subjects about disclosures, regardless of Deloitte's capacity to identify them. My preliminary assessment is this is an important shift. It moves the law beyond the very German binary debates of the past and towards a contextual, functional understanding of what is personal data. It aligns with the realities of modern processing, where data is combined, recombined, and assessed in complex ecosystems, and data protection authority needs to follow. This judgment also resonates with previous case law, such as in the Breyer case, but now it provides more explicit guidance. It confirms that pseudonymization is not a free pass. Controllers must still assume responsibility, and transparency obligations remain. The broader impact is likely to be significant. All DPAs, both at national level and both here in the EDPS, must draw on this reasoning when assessing pseudonymized data. Courts across the EU will have to work with this. And for us at the EDPS, it strengthens our hand in supervising EU institutions that rely on pseudonymization as a compliance strategy. Let me also note, while one procedural aspect has been referred back to the General Court concerning rights of defense, the substance is clear. The notion of personal data is now confirmed, contextualized, and clarified. Let me turn now briefly to the future. 3 priorities stand out: accountability, new technologies, and international cooperation. So everything which you've been discussing in the last 2 days. Accountability is the backbone of modern data protection, and controllers must not only comply, but demonstrate compliance. Data protection impact assessment is and are one of the most powerful tools for this. We in the EDPS have recently surveyed EU institutions on their use of DPIAs. The results show progress. Since 2018, 242 DPIAs have been carried out, and that's a significant increase from only 17 in 2020. But there are concerns. 31 institutions have never conducted a DPIA. Many DPIAs focus only on security risks, neglecting risks to individual rights and freedoms. Too few DPIAs include data flow diagrams or detailed proportionality assessments, and the involvement of data protection officers is often missing or poorly documented. So our concerns are that institutions may be too optimistic when assessing risks. The temptation clearly is to downplay risks in order to avoid a proper DPIA or a consultation. This undermines accountability. Our message is simple: when high risks remain, the next step is not to wish them away, but to consult the EDPS. We will update our DPIA guidance. We will provide more practical advice, and if necessary, also revise our list of processing operations requiring DPAs. For the EDPS, DPIAs are not bureaucratic hurdles, they are learning tools. They help controllers understand what is at stake, and they give supervisory authorities insight into technological and organizational change. With the rise of AI, this becomes even more important. I mentioned AI, artificial intelligence. That's not just the best buzzword, but it is rapidly becoming also part of the EU administration. Translation services, case management, document analysis, AI is entering and has entered the daily work of EU institutions. This brings opportunities, but also risks. Transparency, explainability, fairness are not optional. We expect EU institutions to assess these technologies critically, not to adopt them uncritically. DPIAs will be indispensable. The EDPS is already preparing updated guidance on the responsible use of generative AI in EU institutions. And of course, we are working on internal workflows with our EDPS colleagues, who are the market surveillance authority for EU institutions under the AI Act. Finally, international cooperation. On the 4th of September, the EDPS has issued an opinion on the proposed UN Convention Against Cybercrime. As you will know, the convention seeks to establish common global rules for preventing and combating cybercrime, including the exchange of electronic evidence. The aim is legitimate, but the cooperation must not come at the expense of rights. The EU has high standards for data protection and privacy, and these must not be diluted in international agreements. We emphasized that member states must carefully verify in each case whether transfers of personal data under the Convention comply with EU law. Where the conditions are not met, cooperation should be refused. Let me conclude. The EDPS faces a challenging but vital role. We must enforce compliance within the EU institutions, we must contribute to legal clarity across Europe, and we must anticipate new challenges from AI to cybercrime. We have three priorities: effective supervision and enforcement, legal clarity and coherence, and forward-looking accountability. Our ultimate goal is simple but profound. We need to protect the fundamental rights to privacy and data protection across the European Union's own institutions. Thank you for your attention.
Thank you very much, Mr. Zerdick, for these insights and for once again attending the Bitkom Privacy Conference. We don't have any questions so far, so thank you very much. We hope to see you again next year, maybe then even in Berlin or on a panel. Thank you very much and have a nice afternoon.
Yeah, thank you. Dankeschön. Bye-bye.
Bye-bye.